Okay, thank you, everyone. This is Jeff Atkin. I'm the host of today's webinar and one of the co-chairs of Foley's energy team. I wanted to welcome all of our participants and our presenters to our webinar today of What's Up, the energy policy under the Trump administration. And so to start, I wanted to run through a couple of housekeeping items. And we will be taking some Q&A questions. You can enter those on the left side of your screen, and we plan to address as many of the questions as we can at the end of the webinar. And for those that we're not able to get to, one of the panelists can respond to those directly after. If you have any technical difficulties during the presentation, there's some links there and a help guide to click so you can kind of get some help on that. We will also be making available a copy of the PowerPoint presentation from this slide later in a few days after the event. The webinar is also eligible for a CLE credit, which our team at Foley will process. And if you did not supply your CLE information, your bar information and numbers yet, when you registered, you can do that by emailing, and there's an email here for Kayla on the slide here that will be sent around as well later, and get that. It usually takes about 8 weeks to get that processed. For certain states, if you're licensed in Kansas, New York, or New Jersey, those CLE programs require a special 5-digit code to be entered. Later toward the end of the webinar, we will provide that code, and so you'll need to write that down or keep track of that so that you can provide that as well. So with that as the general background, I wanted to jump in to the webinar. And so today's topic, we're going to cover 2 primary topics. The first is sort of the state of proposed tax and other kind of energy-regulated or energy topics. The second will be really more tailored to the state of environmental regulations. And on our group here of speakers, John Eliason, who is a tax partner in our Washington, D.C. office, will cover the first topic on taxes and other energy items. And then Sarah Slack and Pete Tomasi from our Wisconsin offices will cover the environmental regulations. As sort of a little, and I guess to sort of set the stage for the webinar, it's helpful to look back and just kind of what's happened over the last couple of years. And if you look at sort of the industry trends we've seen for the past 3, 4, even 5 years, there's really been a shift away from coal and some of the traditional energy and power sources in the U.S., and there's been a move, sort of gradual, continual move into primarily renewable energy. And a lot of this has been driven, in part by regulation that's promoted with tax credits, with restrictions on emissions, with events like that. And maybe even in larger part, it's been driven by cost reductions and price reductions, and primarily with LNG prices dropping, and then on renewables with the cost of equipment for wind and solar and the cost of installations just dropping every year, 20 to 30%. And those are areas that have benefited, I should say, from prior regulations, prior government support, and that have been slightly modified, or that there are proposals that would change that. So in today's webinar, we'll look at and kind of look forward into what the new administration is looking at on both on the tax front, other regulatory fronts, and then on the environmental fronts. So with that, I want to turn the time over to John Eliason to cover on the tax front. So, John?
Yeah, thanks, Jeff. And as Jeff said, today I'm going to be talking about tax reform. There's been certainly a lot of developments happening in D.C. Over the last few weeks, and then and in doing so, I'm going to go through the House bill, the Senate Finance Committee bill, and then kind of after that, I'll talk a little bit about what happens next in the legislative process, and then I'll also, after that, as Jeff had said, I'll also talk briefly about other things that we're following on the energy side that are unrelated to taxes. So when we look at tax reform, I think it's important to think about kind of where we started from, and it really started in earnest a few months ago when the House and Senate agreed to permit the federal deficit to increase by $1.5 trillion over the next 10 years. In doing so, they created the opportunity to have tax cuts. Additionally, the Republicans used parliamentary rules to do it in a way that prevents filibustering, so basically creating an opportunity to pass tax reform on party lines, so the Republicans put themselves in a position to potentially pass tax reform without any Democratic input. The tax reform package that we're going to talk about today represents the biggest change to the tax code in 30 years. So it's quite a dramatic undertaking. I'll note that the last time 30 years ago when this happened, it was done on a bipartisan basis. It was not on partisan lines, and it took about 2 years to get it into place. And we're doing it now in a much shorter time frame. So looking at the House Tax Cuts and Jobs Act, it was recently passed by the entire House, and one of their main goals was to reduce the highest corporate income tax rates from the current 35% to 20%, and they accomplished that effective beginning next year. But to get there, they had to a lot of existing provisions needed to be repealed or limited, and that's certainly what is illustrated in the bill. When we look at the things that energy typically cares about, the energy community typically cares about, there's really a big three of tax benefits. There's the production tax credit, the investment tax credit, and accelerated depreciation. The House bill touches on all of these. Starting to kind of look at these in order, the investment tax credit, or ITC, it's currently a tax credit that's equal to 30% of cost, and it's available for solar and certain other renewable energy technologies. It starts to phase down beginning in 2020, and eventually, when we get to 2023, the ITC settles to 10%, which is a permanent ITC amount for all projects otherwise eligible that are built after that date. When the ITC was last extended in 2015, the legislation did not extend it to all technologies. So if you were a fuel cell developer, you were not happy with the 2015 extension because you essentially lost your ITC after 2016. The House bill corrects that. The House bill extends the ITC to fuel cells and other orphan technologies. That was kind of looked at as a corrective matter, and it's interesting to see it added here, where they're looking to eliminate credits, eliminate benefits, and yet they've extended it here to all technologies. The House bill also eliminates the 10% permanent ITC beginning in 2028. So in other words, after that date, you no longer get any ITC with respect to your project. That's considered pretty far into the future when you're looking at this, so it's not received a lot of pushback from industry, with the thought that 10 years from now, who knows where we're going to be. So I think you kind of look at that and you compare it to what they did to the production tax credit. So currently, the production tax credit, it's a credit equal to 2.4 cents a kilowatt hour of energy produced, and it's a 10-year credit. So that that 2.4 cents per kilowatt hour is an amount that's determined by an inflation adjuster applied to the statutory amount that's listed in the code of 1.5 cents per kilowatt hour. The statutory amount was inserted into the code in 1992. That's when we first saw the PTC. And then currently the PTC is subject to a phase out depending on the project's construction date. So if you started construction in 2016, you'd receive a 100% production tax credit. If you started in 2017, it's 80%, 2018, 60%, and 2019 is 40%, and after that, there's 0 PTCs available. And the IRS, which may be known to many on the phone, the IRS has released guidance in several forms regarding what it means to start construction, including creating a requirement that once you started, you had to have continuous efforts to complete that construction to demonstrate that you actually started. However, the IRS guidance also provides very favorable safe harbors, and that's allowed people to go out and do their PTC qualification strategies to basically reserve projects that reserve 100% eligibility for projects that would be finished in the future. So the House bill does really two things to PTC. It eliminates the inflation adjuster for projects started after the date of enactment. So that means that the PTC goes back to 1.5 cents per kilowatt hour, basically putting in place the credit amount that was enacted 25 years ago. Based on the effective date, it's not going to impact operating assets that are relying on the PTC. It's also not going to impact projects that are already under construction, but it still is a dramatic shift, and if it became law, it'd be something that folks would have to be considering closely in future projects, and also if they're looking to repower existing ones. So then the other change at to PTC is the House bill to also codify the IRS's rules regarding what it means to start construction. So they're basically adding a continuous construction requirement. So when the legislative text first came out, there was a lot of concern in the industry regarding the wording. The question was whether the House was looking to override what the IRS had done, or perhaps the House may have felt that the IRS had gone too far. There was a clarification that came out about maybe a week and a half after the initial legislation came out, basically stating that in an explanation that the House Ways and Means Committee actually intended to codify the IRS guidance, so that's calmed down folks a little bit. That being said, if it becomes law, our expectation is that there will be a request for some confirmatory guidance from the IRS, just basically saying, yes, that's how we interpret it too. Our guidance still applies. So then looking at accelerated depreciation, or here really bonus depreciation. So this is under current law, you can take a 50% immediate expensing on capital investments of equipment, and what the House bill does is it modifies that and increases it to 100%. There's been a lot of press about the desire to create immediate expensing, and this is what we're seeing here with the 100% bonus depreciation. It also does something interesting, is that it extends it to all equipment. While currently in kind of the history of bonus depreciation, it's always only applied to new property. So here the House bill is extending it to new and used property. Now that 100% bonus goes away after 2023. So it goes away after 2022, right? And so it's a limited benefit. But that's how the proposal is set up. Now we had a little slide preparation malfunction here, so we kind of swept a couple other changes in the House bill that are under this bonus depreciation slide, but I'll just cover that real quick. So the other thing the House bill does is it it limits interest deductions for small businesses, and their definition of small business is $25 million or less of gross receipts. They are limiting interest deductions for small businesses to 30% of adjusted taxable income, and that's basically taxable income without taking into account the interest deductions. That rule does not apply to regulated public utilities. So now we'll talk about the Senate Finance Committee proposal. So the Senate Finance Committee proposal comes out a little bit later. They're following the House by a couple weeks, and this proposal has been approved by the Senate Finance Committee, and then just yesterday it was approved by the Senate Budget Committee. So now it's going to go to the full Senate, and it's expected that it'll be voted on by the full Senate either late Thursday of this week or Friday. So similar to the House bill, the Senate bill gets to a 20% corporate tax rate, which is what they were shooting for as well. But for them, that tax rate doesn't kick in until 2019. So they delayed it for a year so that they could cost the bill in a way that would stay within kind of that $1.5 trillion additional deficit amount. The Senate proposal, let's see here, let me advance the slide. The Senate proposal is silent on ITC and PTC, so it doesn't touch it. In doing so, it's preserving the status quo for the credit space. So once again, if you were a fuel cell developer or someone else in one of the orphan technologies, you're not happy right now because your House bill is providing for an extension for the credit to you, and here the Senate is silent on that. The Senate proposal has created some concern for taxpayers with significant foreign affiliate transactions by creating a minimum tax to combat what's known as base erosion. Base erosion basically means the occurrence of something that causes the U.S. tax base to be reduced. And here it's where a U.S. taxpayer enters into a transaction with a foreign affiliate and then claims a business deduction off their U.S. taxes as a result of that. For example, maybe you have an affiliate in India that the U.S. taxpayer is paying for back office services. That payment would be deductible for U.S. tax purposes, and so it would reduce tax liability. So if these affiliate transactions result in a 4% or more decrease of tax liability, then the base case minimum tax, the base erosion minimum tax may apply. And if it applies, it ensures that there's a minimum of a 10% tax that the U.S. taxpayer would pay. So the issue, when we look at it and how it impacts energy investing, is that a lot of the multinational banks are also tax equity investors, and they also have lots of foreign affiliate transactions. So if the minimum tax applies to them, then the concern is that they were expecting to be able to benefit from certain tax credits, but because the minimum tax is applying, they're not getting that full benefit. And the complication is that you do that calculation and determination at the end of the year, and in doing it at the end of the year, it kind of creates uncertainty as to how many tax credit deals that you could invest in, because you don't really know how it's going to come out for you on the minimum tax. It's an annual calculation, so if you're looking at like a production tax credit transaction, maybe a wind deal that has credits over the next 10 years, it just heightens this uncertainty as to whether you'll actually get the benefit of it. It doesn't affect all tax equity investors. and there's certainly been a lot of pushback by lobbyists and with senators and their staffers trying to explain this and how this is detrimental to the industry. But a couple of the issues from that is that first of all it's hard to explain. It's hard to explain the impact and whether there really is one, whether there's really truly an absence of other people who will step up and fill the gap created if some multinationals kind of step away. And then the other thing that we're seeing and talking to staffers and others in the industry are that the legislators are suffering from renewable energy fatigue. The industry associations have continually gone asking for changes and adjustments and things, and they're just kind of, they're starting to kind of become deaf to it just because they discuss it so much. So beyond that, the Senate bill generally follows the House. With respect to bonus depreciation, they've also have the 100% bonus, although they're not extending it to used property. So they're kind of really keeping it closer to current law. And then on the limitation on the interest deductions, the Senate bill has a similar limitation, but it only applies to a smaller group of businesses. So they base theirs on $15 million of receipts instead of $25 million. Okay, so when we look at this, what happens next, and I think that in talking through that, we've got to assume that the Senate bill gets voted on and passes this week. Now that's a big assumption. There's certainly it's a very narrow vote, and there's certainly some Republicans out there that are not excited about the bill and some of the things it does. What we're seeing though is we're seeing President Trump and the administration and also the Senate Republican Senate leaders really getting in and cutting deals to try to get senators on board. And so I think it is likely that it could pass this week. If we assume that it does pass, then the House bill, the House and the Senate, they have to get together in basically a joint conference to kind of meld these two bills together to create one bill. Just a bit of like an 8th grade civics reminder. The House and Senate have to agree on a single bill and have to pass it on both houses before it goes to the president for signature. So until that happens, there's really not a law there. So that's the process that's going to come next. And the timing is interesting because the president has said that he wants the legislation signed by Christmas. But there's this complicating factor is the special election in Alabama with Senator Moore, Republican Alabama, that has kind of faced these charges of sexual abuse or child abuse or things that you typically don't want to look for in an elected official, and he's refused to step down. So there's actually there's a chance that the Republicans might lose that seat. If they lose that seat, then they'll only have a one-person majority over the Democrats, which really limits the amount of votes that they can lose to get this enacted. So the thinking is that so that election is on December 10th. So the thinking is that the Senate will want to approve the final bill by the 10th, because if we assume Senator Moore loses that seat, his replacement would be seated on December 12th. So it's only a couple days later. So it should be really interesting. I think we're going to learn a lot next week because that's really only gives them a week and the weekend to really get anything done. Okay, moving past tax reform, and just to spend a couple minutes talking about other things that we're watching. The Suniva trade case is out there, and we're certainly seeing some things materialize there. So this is the trade case in which Suniva and SolarWorld, two U.S.-based solar panel manufacturers, they claim that the imported solar panels were priced in a way that harmed them. It created harm for them. The International Trade Commission, in looking at it, they agreed unanimously, and then after that recommended tariffs on imported solar panels to level the playing field. The simple risk that there could be tariffs has already had an impact on developers, solar developers out there, because it's caused prices to go up as developers have scrambled to secure panels in advance of a decision. So that's already been having an impact. And the other thing that we're seeing is that the tariffs would be hard for the industry, really, if you kind of look at project development, because many PPAs, more recent PPAs, are skinny already, and might not be able to support kind of higher construction expenses that would result from a tariff. Green Tech Media estimated that this is on the slide, that the price impact could be up to 6 cents a watt on imported solar cells, and 10 to 15 cents per watt on modules, which then would decline over the 4-year period. So what we're waiting to see now is it's really kind of on President Trump's desk about whether he's going to agree with the ITC recommendation, or apply a different tariff amount, or listen to many in the industry who are saying that this is really not what we need here, because it hurts U.S. jobs to put a tariff in place. He has until the middle of January to make that decision, and the expectation is that if he applies a tariff, is that we're going to see retaliatory tariffs on U.S. exports. So that's something that'll have to be taken into account in making that decision. We're also watching what's going on in FERC right now. So in August of this year, FERC finally regained a quorum of commissioners, so it can actually start doing things again. And they've got a backlog. The Trump administration has really put a focus on pipelines, and that is now we're expecting, and we're seeing a focus on FERC on the backlog of pipeline approvals, gas pipeline approvals. So they're certainly looking at that, and we're watching that. The other thing that FERC is dealing with right now is that they're looking at grid resiliency, the grid resiliency rules. There's a notice of proposed rulemaking out by the Department of Energy, looking at supporting baseload generation, and here baseload generation is defined as coal and nuclear, and supporting that in a way that the thinking would be that it would improve grid resiliency. As part of that, we're watching a statement from one of the commissioners regarding the imposing payment obligations as a temporary measure, imposing payment obligations on regional grid operators that could cover shortfalls for coal and nuclear. That's opposed by non-coal and nuclear operators, as you might expect. The other thing that FERC is looking at right now is they're looking at battery storage. I mean, we're seeing batteries in lots of projects these days, and that's going to increase. And it also provides a good opportunity to help manage the load on a grid, and that's something that they're looking at, and we're expecting to see something this year on that. Okay, we're also kind of watching what's going on with PURPA, although maybe the lead-in on that is that it doesn't seem to be much right now. But the House held a hearing on whether to get rid of the requirement that utilities must enter into PPAs with qualified facilities. These are the facilities that are 80 megawatts or less. And the claim is that requirement that leads to building projects where they really aren't needed. The other thing that people in favor of getting rid of that requirement that look at is that developers are breaking projects up into ways that get them kind of under that QF designation that really maybe shouldn't be broken up in that way. Here, FERC is really saying, hey, this is up to Congress, so we're not really expecting FERC is going to act with that new legislation, but it's something that we're certainly following. Okay, so that takes us through the tax reform and some of the energy items that we're looking at, and I'd like to now pass it off to Sarah and to Pete to talk about some of their environmental updates.
Thank you, John. This is Pete Tomasi. Sarah Slack and I will now touch on something non-tax related, which is a series of recent environmental updates. Some of these you may have heard of. Some have been in the news, in particular the Clean Power Plan, and some may be less familiar to the listeners, and we'll try to run through them and give a little background. Okay, so most people are familiar with the Clean Power Plan. This was one of the signature initiative of the previous administration, designed based on existing US EPA Clean Air Act authority to reduce emissions, CO2 emissions and CO2 equivalent emissions from electric generating units. The rule itself, we could spend an entire webinar on, but in short, the implications were EPA created a multiple building block strategy to reduce emissions from existing generation under Section 111D of the Clean Air Act. It was a novel rule. It was most novel because it did two things that were considered to be first for EPA regulations. It utilized so-called outside the fence line, things like wind and solar to offset emissions from some existing facilities. And it also functionally would have reversed some of the dispatch order depending upon cost of natural gas versus coal-fired units when coal was otherwise more economically favorable. The plan itself should have been well underway by now. States were initially required to submit so-called state implementation plans in September of 2016, and there was a subsequent extension to 2018, but most states were expecting to be near the point of completion with their plans, and then looking forward to two compliance targets in 2022 and 2030. Because of the novelty of the rule, it was challenged by a number of states, number of organizations that were either on legal grounds or because of the implications for existing industries that would perceive themselves to be negatively impacted. And in a highly unusual move, before the case had been briefed in the court below, in the Court of Appeals for the D.C. Circuit, the U.S. Supreme Court issued a stay in February of 2016, which is a little odd in light of my last bullet on the next slide. The Clean Power Plan was a very hot topic during the 26th election. It is an issue for the current administration, and there was an executive order issued in March, first addressing a notice to review the Clean Power Plan. More recently, there was a Federal Register notice issued proposing repeal In the meantime, the litigation in the court below in the D.C. Circuit continues to be stayed for 60-day periods, which began in April. The D.C. Circuit decided not to try to do an end run around the U.S. Supreme Court. So why is EPA proposing repeal? Fundamentally, this is just a legal issue that has been raised in the litigation that has stayed in the D.C. Circuit. Fundamentally, EPA has proposed as the so-called best system of emissions reductions that was required under the Clean Power Plan, the outside the fence line measures. Prior rules had never done this before. And either under Section 111D or under related provisions for new sources under Section 111B of the Clean Air Act. And EPA now, under the current administration, has reconsidered the position taken by the last administration, is moving forward with 2 days of public hearings. There were hearings yesterday and then today in Charleston, West Virginia, which is a state that has a significant coal industry. Comment period is open through the middle of December. In the meantime, at a November 15th speech, I believe before the Federalist Society meeting, Administrator Pruitt stated that US EPA would soon issue an advance notice of proposed rulemaking to replace the Clean Power Plan. In the meantime, some groups are pushing for a repeal of the underlying endangerment finding. In addition to the Clean Power Plan, EPA is working on other rules that have implications for coal, one of which is the coal ash rule, and I'll just touch on this briefly. Historically, under the hazardous waste regulations implemented by US EPA, there was a set of wastes called bevel wastes, and coal ash was initially treated under a separate process from other potentially hazardous materials. In 2014, US EPA issued updated regulations to try to revise how coal ash is handled by states in light after a significant spill had occurred at an impoundment in North Carolina. After those rules were unpopular, and in 2016, Congress passed a legislation that, in theory, put limits on EPA's rulemaking and implementation. In light of that revised legislation, the underlying 2014 rule has been litigated, and the implications, if any, of that 2016 legislation are currently being heard before the D.C. Circuit. A decision is not expected until next year. The implications, before I move forward with two other updates, notwithstanding campaign promises, there continues to be a push, primarily driven by the market, towards natural gas, and the existing regulatory environment still is more stringent on coal than natural gas. Although EPA did separately propose a methane rule for oil and natural gas wells, there's a presumption or some perception that there have been significant emissions of methane from drilling operations, from fracking, and ENGOs in particular have been pushing EPA for information on compliance. The new administration tried to stay the rule, and that stay was struck down by a federal court. Now EPA has put forth notices of data availability, proposing two separate approaches to staying the rule going forward. Briefly as well, one other update on other air emissions. Ozone is a criteria pollutant and is one of the main drivers of emission controls, in particular for the power sector. EPA revised and tightened ozone standard in 2015, and the agency has been pushed to issue designations to identify what areas are in compliance with standard and what areas are not. EPA has only identified the attainment areas so far, and they're being pushed by a coalition of states in the Northeast to publish the full list as soon as possible. Briefly, new source review regulations. This is a set of Clean Air Act requirements that is probably the most heavily litigated issue under the Clean Air Act and the most difficult compliance issue under the Clean Air Act. The current administration has signaled an interest in putting together a task force to revise new source review compliance. This is a positive. Ultimately, I think industry is cheering this initiative, but it's really unclear without legislative reform of the act itself how much the EPA can do if Congress chooses not to act. Final brief point, renewable portfolio standard, which is not generally considered an electric generation related matter, but under applicable statutes, EPA has to set volumes of renewable fuels every year by November 30th. And currently, the advanced cellulosic lobby is pushing US EPA to increase the levels under what, as opposed to what EPA proposed to require in July. Somewhat interestingly, cellulosic biofuels do include biogas, and we have seen cellulosic biogas systems where landfills are now shipping biogas through interstate pipelines and are generating RINs which they then sell on the open market to refiners. The same lobby is also pushing EPA in a November 9th white paper was submitted to EPA to get the agency to consider the issuance of renewable fuel credits for facilities that burn biogas, generate electricity on the theory that that electricity can then be used to charge electric vehicles and is an additional form of renewable energy. And with that, I will hand things over to my partner, Sarah Slack, to talk about the Waters of the United States rule.
Great. Thank you, Pete. As Pete indicated, my name is Sarah Slack, and I've got a couple updates I'm going to discuss with respect to some happenings under the Clean Water Act and under the Endangered Species Act. So first, with respect to the Clean Water Act, I wanted to give an update on the Clean Water Rule. So the Clean Water Rule was issued under the Clean Water Act, and what it is a definition of WOTUS, or Waters of the United States. The definition of waters of the United States has a long and very controversial history because that definition basically decides whether or not a water or a wetland is subject to federal jurisdiction. So going back for decades, there has been some back and forth between the Supreme Court and then also EPA issuing various forms of guidance. Most recently, the Supreme Court decision in Rapanos versus the United States resulted in a 4-1-4 split decision of the court with respect to what the definition was of waters of the United States. So Justice Scalia, in this case, wrote the plurality opinion, and basically his position was that waters of the United States and the Clean Water Act jurisdiction covers really only those kind of traditional navigable waters and the non-navigable waters that have relatively permanent flow. And then with respect to wetlands, that the limit of federal jurisdiction was really just to those with a continuous water connection to those otherwise obviously jurisdictional waters. Now, the one in the Rapanos decision was Justice Kennedy, and in his concurring opinion, he took what has been considered to be a much broader view of the jurisdiction of the Clean Water Act. And his position was that to the extent that a water had a significant nexus to waters of the United States, that it was in the scope and jurisdiction of federal waters, and therefore would be subject to Clean Water Act permitting requirements. There was, again, between 2006 and 2015, there were several different versions of guidance documents that were issued by the Corps. So the Army Corps of Engineers has primary authority with respect to these waters of the United States and the associated wetlands. And really the effort there was to try to provide some additional guidance to the regulated community about what is a water of the United States, because again, that has a direct impact on whether or not a project may be required to obtain a federal permit to impact, fill, dredge, or any of a variety of different types of impacts to waters of the United States or their associated and related wetlands. So in 2015, there was an Obama-era rule. It was variously called the WOTUS rule, or I think the Clean Water Rule is what is commonly referred to at this point. And that was generally considered to be based on Kennedy's standard, which was that the agency really made an effort to try to use the significant nexus rationale for what waters would be considered jurisdictional under the Clean Water Act. So then in 2015, when that rule came out, it was subject to numerous challenges from industry. There was a general outcry amongst industry that the scope of the new rule greatly expanded the scope of federal waters. There were a number of filings in different courts, and ultimately the Sixth Circuit stayed the rule pending a decision on a jurisdictional question as to which court had the appropriate jurisdiction to hear the challenge. And that, excuse me, that has been stayed, and actually there was an oral argument before the Supreme Court on this jurisdictional issue that occurred in October. So we're awaiting a decision on that question. In the interim, President Trump campaigned on, one of his campaign issues was on withdrawing the Clean Water Rule, again, taking the position that the new rule was overly broad and therefore was overly burdensome to development and industry. And so with respect to the current status, so the current status is, initially, I'll note that the Sixth Circuit stay is still in place pending that decision from the Supreme Court. And then since President Trump has come into office, there have been a couple of updates as well. First, in February, President Trump signed an executive order that called for the rescission and then ultimate revision of the Clean Water Rule. In that, he specified that it was ultimately to be that the Scalia position would be what he promoted with respect to what the standard should be, so kind of backing off from the Kennedy position to the Scalia decision. And then in March of this year, there was actually a rule was filed to rescind the Clean Water Rule. And comments on that were actually due just yesterday. So that is still pending at this time. Then in addition, more recently, just earlier this month actually, EPA proposed to extend the effective date of the existing Clean Water Rule. Now, the reason for that seems to be that the agency is hedging a little bit because there's a concern that once the Supreme Court issues its decision on the jurisdictional question, that there may end up being, that the stay may be lifted. And so the agency is now proposing to extend the effective date to 2020 so that if that happens, then the Clean Water Rule would not be in place, but the prior rule would be, which would give the agency time to promulgate a new rule, which, based on recent information from EPA, is that a final decision on WOTUS won't be released until March, and that the rewritten regulation is not expected to be in place until 2018 at the earliest. So, again, that would just give the agency time. So again, the status is that the definition of what a water of the United States is certainly in question. And the complication for the energy industry in particular is that can have implications on siting questions and on other elements with respect to what is a water of the United States, because again, there are numerous regulatory implications to something being a water of the United States. All right, and at this time, we have our CLE polling question. So if you are looking to get CLE for this program today, please enter this 5-character code into the poll question on the next slide and press the Submit button. So the code is 55FF1, or excuse me, I. 55FFI. And I'm just going to pause for a couple of seconds to allow everybody on the call to enter that information in. All right, we're going to go ahead and proceed with the rest of the presentation. Oh, so here is the actual slide where we need to enter in the code. So again, I'll give everyone a few moments to enter that in. 55FFI. All right, moving on. I also wanted to talk a little bit about some updates under the Endangered Species Act. So the Federal Endangered Species Act was first enacted in 1973, and it protects species that are listed on the federal list as endangered or threatened from takes. And there's a very broad definition of take under the statute. It includes killing, but it also includes things such as disrupting or taking away habitat, impacting nesting species, things of that nature. So a very broad definition of takes and what is regulated under the Act. So this, in general, there's a general understanding that industry dislikes the Endangered Species Act, mostly because it adds additional layers and oftentimes, or sometimes, complications to land use decisions. So, many industries can be impacted by this, especially to the extent that they may be required to comply with NEPA or if there is any federal element of approval for a project. So if that's the case, then a consultation with the federal government is going to be necessary with respect to potential impacts to species. And this can have significant impacts on a number of different industries with respect to siting of facilities. And in particular, there have been issues with respect to the siting of both more traditional energy projects as well as renewable projects, especially wind projects. And so with respect to, kind of what's been going on, the Trump administration has been very critical of the Endangered Species Act. In fact, I believe that the quote that I have heard is that, there's the consideration that the Endangered Species Act is a disaster and that it's just overly broad and unduly burdensome. But that being said, there hasn't been a whole lot of action to date with respect to this. There was some withdrawals of some pending regulations that happened back in March and April that was pretty quiet. So 42 different pending regulations for some various species that occurred in March and April. But other than that, there's been very little actual change or action from the Trump administration on the Endangered Species Act. But there's also the potential that Congress could take the initiative. And here in particular, we note that there have been several bills that have been recently proposed which would indirectly impact species review. So for example, the Secure American Energy Act recently passed the House Natural Resources Committee in early November. And under that act, that would affect on and offshore oil and gas projects. And what it would do is it would basically give certain elements of permitting requirements for those projects over to the states. And that would allow projects to basically bypass the Endangered Species Act consultation for certain projects, especially to the extent that those projects may be on BLM, Bureau of Land Management properties. So, in general, this is consistent with the general policy of we're seeing of starting to push more regulation to the states, but it is an interesting kind of way that we may see some impacts to the Endangered Species Act by just taking those required reviews or the reviews that are required under the existing statutory scheme, away. All right, so with respect to implications, so again, as I mentioned earlier, I think that one of the big issues here is there's a lot of continued uncertainty on the Clean Water Rule, both because we don't have a revised rule yet that fully articulates what the current administration expects the standard to be, but then also because there's ongoing concern about the back and forth of potential change in administration and a concern that acting in a certain way now may not be the agency's perspective in another 4 years or possibly 8 years. So just some continued uncertainty, which makes it difficult at times to know what the standard is and where federal permits are going to be required. The other kind of question is, what are the states' roles, both in protecting species and protecting waters under the Clean Water Act or under the Endangered Species Act? States vary widely with respect to whether or not they have their own acts, and so to the extent that that a state may have those protections in place, it may be that there will be increased levels of protection. I note that recently New York State has used its 401 authority to block certain federally approved projects because a 401 certification is required from any state in which a federal 404 permit has been issued. So for those projects, there's the capacity for states to take that role on. And then another question that we have is, what about citizen suits? We see the potential for these to be an issue both with respect to the scope of waters of the United States, so kind of in the traditional sense of which standard applies. But then also, in addition, there's been some interesting actions in the Fourth and Ninth Circuits recently with respect to whether or not groundwater migration can lead to Clean Water Act jurisdiction. So in those cases, the question is whether whether, for example, an injection of water into the ground that ultimately migrates to a federal jurisdictional water, whether or not that will trigger Clean Water Act jurisdiction. And again, so the decisions in those cases may ultimately impact the scope of what the definition is for waters of the United States. And then just more generally, challenges to agency decisions and permits, the more traditional citizen suits that we've seen, and just that there may be increases in those. So with that, I think we are at the end of our prepared presentation, and we're happy to take any questions.
All right, Sarah, hey, this is Jeff. So it looks like without any questions, we'll follow up with folks after, and we can close. So thank you all for joining.